Hello everyone, and welcome to another Lancaster Safety Webinar Wednesday. My name is Alicia, and I'm here with Rick, one of our safety consultants, to discuss a topic that we hope will bring clarity to situations that many consider to be very intimidating for employers. We hope to help everyone stay up to date on what you should expect at an informal conference. Everyone in here today wants to make sure that they're prepared in the event of an OSHA inspection, and everyone here at Lancaster Safety Consulting also wants to make sure we can help provide the resources to just do that. A little background about Lancaster Safety: we're a full-service OSHA compliance firm that has a primary focus on making sure each employee gets home safely from work each day. Our slogan is taking safety beyond the standard. This means we want to go above OSHA standards and make sure our clients are building a safety culture, being safe because they want to, not because they have to. We want to provide a top-notch service that really makes an impact in people's lives. With that being said, today we will be looking at how you can prepare yourself and your company for an informal conference. So what are your main goals to talk about with our audience today?
So before every informal conference, the employer will want to make sure that they have a plan in place going into that meeting. They certainly never want to just wing it. Normally, the OSHA host will follow a certain agenda when conducting the informal conference. However, this is not always the case. They will begin by reviewing the rights of the employer to contest the case if needed. Next, the citations and penalties will be discussed with the host, and they will answer any questions to provide clarity. If necessary, the abatement extensions, financial limitations of the company, related standards, possible violation reclassifications, and so forth will also be discussed as necessary. If any of the violations can be abated at that time, those items will also be submitted to the OSHA host. Special circumstances, such as non-admission and exculpatory language, can also be requested as well. It will then be determined if the case needs to be contested or if an informal settlement agreement can be reached on at that time. Before we dive into the specifics of the citation process, the informal conference process, and so on, we would like to define a term that will be commonly used throughout this webinar. OSHA defines the word abatement as action by an employer to comply with a cited standard or regulation or to eliminate a recognized hazard identified by OSHA during an inspection. So basically, it's essentially a fancy word for fixing the hazards. In short, abatement is a commonly used word that refers to the corrective actions that have been taken to eliminate a recognized hazard identified by OSHA during the inspection. Within the citation packet that you receive, you will also see an abatement date or date by which violation must be abated. This identifies when OSHA expects the hazards to be corrected by and the proof of abatement or abatement documentation to be submitted to them as well. After a company has been inspected by OSHA, they may or may not receive citations in the mail. If you do, however, you will see abatement dates and penalty amounts, like I just previously said, that may make you a little bit nervous, but not to panic just yet, as those dates and numbers are not set in stone at this time.
So if you do receive citations in the mail, how long do you have to reply to them?
The federal OSHA requirement for applying to citations is 15 working days from the day the citations were received via certified mail. The packet will require a signature upon receiving.
So whenever I receive the packet, what would I do with it?
It is definitely a good idea to keep those citations readily available on file to reference quickly if needed.
And do I need to let my employees know about receiving the citations?
So federal law requires that a copy of the citations and notification of penalty to be posted immediately in a prominent place or at or near the location of the violation cited in the packet. However, if that is not feasible to post them at that exact spot due to the nature of the employer's operations, they shall be posted in a place that it will be readily observable by all affected employees, such as a bulletin board that's regularly viewed by employees.
And how long do I need to keep them posted for?
So the citations must remain posted until the violations cited have been abated, or for 3 working days, whichever is longer.
Once an informal conference is scheduled, what should an employer expect?
So this conference or meeting with OSHA does live up to its name as informal. This is an employer's opportunity to discuss the citations with the area director or assistant area director and potentially come to an agreement at the conclusion of the meeting. During this webinar, we will review the procedures of an informal conference, what can be done to adjust the timely dates and lighten the penalty amounts, and it is every employer's right to request an informal conference with OSHA to discuss the inspection, any additional related issues regarding the citations, notice of proposed penalties, or the notice of intention to contest the case. These are held at the OSHA area office that issued the citations.
If I'm understanding this right, simply put, an informal conference is a follow-up meeting with OSHA after a company has been inspected. Is that correct?
Yes, that is correct. This is the employer's opportunity to have a company representative meet with OSHA, whether it's in person or over the phone, to discuss citations and potentially come to an agreement.
All right, so we have an Insta-Safety quiz question for you. What does the term abatement mean? A, actions taken by an employer to eliminate hazards. B, when a citation packet is received from OSHA. C, the act of an employer paying the penalty amount. D, a common term used by OSHA when referencing hazards that have increased in severity. We'll give you guys a few seconds just to answer those questions. All right, we're getting some good responses. Keep them coming. All right. So the correct answer is A, actions taken by an employer to eliminate hazards. The term abatement is referring to the actions by an employer to comply with a cited standard or regulation or to eliminate a recognized hazard identified by OSHA during an inspection. So Rick, you mentioned that generally an informal conference must be scheduled within 15 business days from the date that the citations were received by the employer in the mail. Is that number set in stone, or do employers have some flexibility with it?
So this length of time can vary depending on the local state regulations. Generally, it's less than that if that's the case. The issuance date listed on the citation packet is generally not reflective of the date the citations were received. So that's something to keep in mind as well. Weekends and the 10 federal holidays that OSHA recognizes do not count as business days when calculating to the final contest date. Some area offices only conduct informal conferences on certain days at certain times, so it is based on the availability of the OSHA personnel as well. It is highly encouraged that employers attempt to attend the informal conference in person. However, depending on the circumstances, it can also be acceptable for all parties to attend via conference line. This is also clarified when scheduling the informal conference on how everyone will be attending. Like I just mentioned, sometimes they are conducted in person or over conference line. As safety and health consultants at Lancaster Safety, we attend informal conferences with our clients almost on a weekly basis in total. The goal is to discuss and resolve any issues associated with the violations and ideally come to an informal settlement amount agreed upon by all parties.
So since this isn't a typical courtroom type of meeting, is a lawyer needed?
Having a lawyer present is completely optional. It's not required. A lot of Lancaster Safety's clients prefer that we just attend with them to help answer any questions related to their safety program and progress. Sometimes citations can be thrown out completely or the penalty amounts reduced. One additional important item to note is that if an employer brings their attorney to an informal conference, the OSHA host may also contact the regional solicitor's office and ask for the assistance of counsel on their end as well.
So do companies have to have an informal conference, or is there another option provided for them?
No, companies are not required or do not have to have an informal conference with OSHA, but Lancaster Safety does highly recommend that an informal conference is always held, even if the employer does agree to the violations and the penalty amounts. It is still an opportunity to sit down with OSHA, have a conversation with them, let them know where they stand as an employer as well. While OSHA does trust that the safety of the employees is in good hands, it lets them know that the employer is working towards their overall mission of an injury-free work environment. The alternative to this is to simply accept the citations, accept the fines, pay the fines up front. Signing the informal settlement agreement and paying the alleged penalties waives the employer's right to an informal conference and places the violations into final order. So once they're paid, that's it. Once an employer has acknowledged the violations in this manner, they do move from the alleged violations to actual violations, which can lead to several issues down the road, depending on the company's size and overall type of work.
OSHA is conducting over 50,000 inspections per year of workplaces covered by the Occupational Safety and Health Act of 1970. So the first thing companies need to understand is the type of violations that can be cited for by OSHA. Signing the informal settlement agreement and paying the alleged penalties places the violations into final order. The employer can gain a better understanding of where they stand and if it needs to be taken further by contesting the case.
Yeah, so on this slide, we show that what the employer's opportunities are at an informal conference. They can discuss violations cited and OSHA standards used so they are better understood, negotiate any monetary penalty amounts and enter into an informal settlement agreement, discuss ways and possibilities to correct these violations, discuss issues concerning the abatement dates associated, resolve disputed citations and penalties as well, which would thereby eliminate the need for more formal procedures associated with litigation before the review commission. And they can obtain answers to any other questions or uncertainties or concern that an employer may have. All in all, OSHA's ultimate goal is to work with the employers to help them make continual improvements to their safety culture and program.
In some cases, an expedited informal settlement agreement, or EISA, may be a letter attached with the citation packet. What exactly does this mean?
So this is essentially the area office's way of identifying an employer's good faith effort and offer them an expedited settlement agreement up front. Even once an EISA is granted, we still do like to encourage taking advantage of the opportunity to have an informal conference. This EISA will also be included within the citation packet if one is issued. This can be used as any time to present an outstanding abatement items and request any extensions that may be necessary. At times, even when the EISA is granted, the area director may be willing to further reduce the penalty on top of that. So listed here are some of the items that the employers will want to bring with them to present at the informal conference itself, or what they can send to the area office after the fact as well. They include photos to provide evidence, written policies and programs that they have developed, training documentation and records, inspection records these are all very important elements that to have prepared to present at the informal conference going into it.
What exactly is a corrective action worksheet, and where can you obtain a copy?
So if this is requested and necessary, a corrective action worksheet can be completed and submitted as abatement. This is found in the citation packet as well. It's essentially what it sounds. It's a signed document confirming that certain items have been abated. If additional abatement is still necessary after the conclusion of the informal conference, this can also be used as a time to discuss potential timeframes of abating the remaining items. It is a possibility that abatement dates can be extended and adjusted accordingly to accommodate the logistics of having the violations eliminated and abated as needed. We will discuss further later on how having these elements in place prior to the inspection can definitely work in your favor.
All right, we have another Insta Safety quiz question. How long do I have to schedule my informal conference after signing for my citations? A, 15 calendar days, B, 10 calendar days, C, 15 working days, D, you can schedule it at any time. All right, send in your answers. Looks like we're getting a tie right now. All right, keep sending those in. Okay, so the answer is C, 15 working days. Just keep in mind that this is aligned with federal OSHA offices and it can differ depending on your state plan. So for example, some state plans may request for you to appeal the citations upon receiving them prior to scheduling the informal conference. So Rick, what is typically the first thing discussed at the informal conference?
Yeah, so the host will typically begin the informal conference by reviewing the purpose of the informal conference itself and discussing the rights to the employer. This includes documenting every individual participating, as well as reviewing the employer's rights to contest the case if an informal settlement agreement cannot be reached at this level. in which case the employer would submit written notice to the area director that they intend to contest such citation or propose penalties before the review commission. If needed, the notice of contest can be given to the OSHA host at the informal conference. However, it can be mailed as well if it must be sent through the mail. Such notice of intention to contest shall be postmarked within 15 working days of the receipt by the employer of the notice of proposed penalty.
So it's obvious that the main topic discussed at an informal conference is going to be citations, but what should employers be aware of during this discussion?
So this is to be viewed as an opportunity. The employer can ask questions or clarify areas that are unclear. It almost goes without saying, but the employer will want to treat the OSHA host with the utmost respect, and they will receive the same in return. This is not the time to argue, but to rather discuss or gain an understanding of the reasoning behind the issuance of certain violations. Employers may only know one side of the story. Some of the information may have been communicated to them from their own supervisor on site during the inspection. This is also when the employer can present proof of abatement for each violation as necessary, and or the completed corrective action worksheet as we discussed earlier. Proof of abatement can be provided in the form of photos, training documentation, inspection records, and so on, depending on what the violation requires and calls for.
So you mentioned before that the penalty amounts received in the mail are not final. How can an employer get those fines reduced?
So this is where Lancaster Safety can really help out clients and companies. We've participated in hundreds of informal conferences and are able to help show the employer's good faith effort, whether that's proof of hiring a third-party safety consulting company like LSCI, or taking overall strides to improve their safety and health program internally. OSHA will view this as a great step towards promoting a safe and healthy work culture. Another area which can grant employers further reductions is enhanced abatement. OSHA can place additional stipulations into the informal settlement agreement that the employer must meet as terms of that settlement agreement. Some of these include, but aren't limited to, regular facility or job site inspections, additional trainings on top of what they've already completed, text-in compliance programs, and even simply following up with OSHA after a few months or a year regarding how their safety program is progressing. If the employer cannot pay the entire penalty at once, a payment plan can also be discussed. Different area offices around the country impose different stipulations. However, generally an interest-free payment plan up to 24 months, paid either monthly or quarterly, can be written into the agreement as well, depending on the employer's financial needs. The employer also has the right to pay off the full amount at any time during the payment plan. However, one additional item to note with this is that there will be no invoicing from OSHA regarding the payments, so it is up to the responsibility of the employer to continue with the payments on the agreed upon schedule, whether it's monthly or quarterly. And this is generally where Lancaster Safety can come into play as well. We can send out reminders to companies, to submit their payments.
So some special circumstances, if the case involves an accident and or health exposure concerns, generally it's chemical or noise, is advisable to request non-admission or exploratory language within the agreement. Essentially, this language signifies that the employer has accepted the agreement for settlement purposes, but does not agree to the violations or admit fault. If accepted and provided into the agreement, this language could potentially protect employers in the future from unforeseen lawsuits. By no means does this not make claims legitimate. However, we've all heard the commercials that ask, has you or your loved one been diagnosed with mesothelioma? You may be entitled to financial compensation. This is one example of a potential lawsuit that could arise if this wording is not included into the agreement. So what if we go through all of this and we still can't agree to the terms that OSHA has with the settlement?
So the employer still maintains the right to challenge the citation before the Occupational Safety and Health Review Commission. However, a decision on this must be made by the contest date, as we discussed earlier. If all other options have been exhausted to this point and an employer can't come to terms due to any discrepancies, they do have the right to challenge the citation before the review commission. Additionally, if the employer has the inability to pay the citation or the fines, many times the OSHA host will suggest that they contest the case and claim financial hardship. This will then allow them time to submit some financial records to to be reviewed by OSHA and possibly, not always, but possibly grant a reduction previously not provided. All in all, once everything has been discussed and a decision has been made on whether the case will reach an agreement or need to be contested, the informal conference will begin to wrap up at that point. At this point, as they say, no stone should be left unturned regarding the case and its violations. It should be clear as to what the next step is, whether it's regarding the settlement agreement, contesting the case, what have you. If a settlement is agreed upon, the abatement items, abatement dates, and payment due dates should be clearly understood before departing. Once the meeting has concluded, the employer will want to remember to thank the OSHA host for their time and consideration in this matter.
All right, an institute safety quiz question. Is OSHA required to give a reduction on the penalty if you spend your time to go to the informal conference? A, yes. B, no. We'll open that up and guys send in your answers. About 50-50 right now. Keep sending those in. All right. So the answer is no. OSHA is not required to issue reductions. However, they may take into consideration some of the items that were provided and can give a reduction on the penalty if they can acknowledge a commitment to safety and are confident that employees will not be exposed to a similar hazard in the future. So before we leave, where can our audience go for further help?
Well, right here with Lancaster Safety Consulting, of course. Our safety and health consultants will be happy to help anyone out there regarding their informal conferences. As I mentioned, we do handle these meetings regularly and have handled over hundreds of them and can offer our experience to help get your company's penalties reduced. We have had lawyers reach out to us for advice and have worked hand in hand with other attorneys and safety professionals. Peace of mind might be the number one thing we have to offer when it comes to informal conferences.
Thank you for taking the time to listen in today. We covered a lot of information in a short amount of time. So if you have any further questions, please call Lancaster Safety at 888-403-6026 and we'll be happy to help. Also, follow us on social media for more news updates and safety information, or provide us with feedback on either Yelp, Google, or Facebook. We truly appreciate your time and hope you'll take advantage of our monthly safety and health webinars. Everyone is invited to attend and they're always free. Just visit our website or click the link on your screen for more information. Thank you and have a safe day.